Okay, we will now move on to Kyle Cicchetti, Governor Higginson, and Outreach and Legislative Affairs Manager Sanjay Walvakar on recommended proposed policy regarding legislative activity of the sections. Those materials are on page 271 of your material.
Thank you, President Manjumdar. Is Director Walvakar on the line?
Yes, I'm on the phone.
All right, great. So we're here today at what I hope to be just a short presentation. We began a process several months ago to refine our policy with regard to who is able to and how the process should be for presenting before the Washington State Legislature. And we began this process for the Board of Governors last year, I think, and then continued on into January when we had our proposal. And at that time, we presented the policy, but it had not yet been fully adopted by the Legislative Committee. So I asked that it be returned to the Legislative Committee for at least one final review and approval. After that, this policy, and you'll find it on page 271, we underwent another attempt or another effort to get additional input from the sections and the parties that might be interested in what we were thinking in terms of guidelines for the sections and for entities to present to the legislature. And we got a lot of feedback, and some of which we adopted, some of which under the guiding principles and confines of 12.2, we weren't able to adopt. But I think with a huge help from Governor Higginson, taking the laboring oar for drafting this policy, we essentially moved from two policies to one policy, which I think makes it a lot more clear and a better program for what needs to happen before sections and folks present before the legislature under the Washington State Bar Association. I want to make it clear because there was some misperception that this policy was intended to step back from supporting the sections, and quite the opposite. The entire purpose of this policy was to be a resource for the sections, continue to have our legislative affairs manager be a resource for these sections, that they can continue to rely on him as the legislature during the legislative session, and then even after and in between legislative sessions for information about bills and the ability to coordinate with the WSBA on legislative efforts, because that's the intent. We want to facilitate that process. We don't want to hinder it. And I'm gonna let Governor Higginson talk a little bit if she has anything to add. But the final policy that we came out is in your materials. We're going to ask for a vote today to approve the policy and thank not only Governor Higginson, but also Member Engagement Chair Hunter, who's not with us today, but was also a tremendous resource to providing information and vetting as this process went through. So with that, Governor Higginson, do you have anything to add?
I only would like to say that I think that this is good work on behalf of the Legislative Committee, the Real Property Probate and Trust section, Executive Committee, the Family Law Executive Committee, Member Engagement, and frankly, Jean Cotton, Grays Harbor Bar Association President, who took the time to actually redline a prior draft of this and sent it to us with some very thoughtful comments. And since she had the history of what had happened in the legislature that caused a problem a few years ago, it was really particularly helpful for me to actually see her comments. So we took as many comments from the sections that gave us the information as we could. We'd previously taken comment from several other sections and worked that in. So we have spent a lot of time on this. I think it's thoughtful. It seems like it will work for sections in helping delineate how they approach the legislature, how they respond to questions from the legislature, requests for information. And Sanjay has been very helpful as well. And I certainly would like to call him out for his thoughtful comments and working with us to help us come up with something that he can live with as in his role, not he personally, but his role will play in this whole policy. And everyone is mostly happy with it. I know some of the sections wished we'd put some more comments, some more changes in, but it's before you now, and I do recommend approval. And also, sorry, I don't have a motion, but I'm recommending approval.
Thank you, Governor Higginson. And I would just like to add that I mentioned before that I've spent 13 or 14 years on the Legislative Review Committee and on this committee for 3 years, chaired it the last 2. And I truly believe this is the second most important thing that we've done in that time period to improve our processes. The first being more coordination with the Legislative Review Committee, which I think is vital to our success. And also, again, I echo Governor Higginson's comments about Legislative Affairs Manager Walvikar, who's done an excellent job this session, last session, and 3 years ago. Appreciated his help. With that, I would like to open it up to Legislative Affairs Manager Walvikar if he has any additional comments.
Thanks, all. No additional comments from me.
All right. So,
After that, Chair Shichetti, if you don't mind, I will call on our General Counsel, Julie Shanks.
Just a quick question. So this policy says that it would supersede and replace our current policy, but our current policy applies to many WSBA entities that are not sections. So I was just wanting to understand how those two things fit together. Thank you.
well, I think it is the intent that it would apply to all entities that would be presenting, not just, well, within the WSBA, because that's the concern and the restrictions for 12.2. So it would primarily for sections.
So the current policy sort of says that it's all, all the WSBA entities. So that's my only question is, does the language or does something need to make clear that it does apply to all the entities, not just the sections?
Well, that certainly was the intent. And I'd have to take another look at it to see your point.
Might I?
Go ahead, Governor Higginson.
So there was discussion, I recall, at one of our meetings more recently, Legislative Committee, I should say, about this issue. And I could be wrong, but it seems like there was some discussion about the fact that we on the board are the ones who ultimately the committees report to, and therefore none of the WSBA committees would actually have the right to independently comment on something. It would have to come to the board, and then the board speaks as the board decides to speak. So, and I think we also had some discussion at some point along the way that the councils that are created by the Supreme Court are not subject to WSBA control or oversight, so we really can't affect them. So it seems to me that the discussion was that sections are independent and often work with the legislature, that our committees and subcommittees are subcommittees and committees of this board, and this board would then act in response to anything they might want to bring forward. That's my recollection.
General Counsel Shanklin, specifically, were you talking about the Supreme Court board or
No,
something
no,
else?
I'm talking about the language difference between this policy that says that it supersedes the earlier policy. The earlier policy applies to more than just sections, so I just want to be clear, if that policy doesn't exist, then can you hear me? I'm not sure what the
No,
You're cutting out. You're cutting out.
Yeah, I don't know what the
the
anyway.
problem solved. It was someone else unmute.
Okay. Just that the previous policy now, if you adopt this, specifically it says that it applies to other WSBA entities. And so if this is its replacement and this only applies to sections, then do we have a whole? Is there no policy then for the other entities? They don't have a process to follow. I'm not.
And I guess my question is, what other WSB entities are you talking about?
Well, any other WSBA entity, any committee, any task force, anybody, any entity that is created by WSBA. And all I want to say is they need some guidance about what procedure they should follow. Do you want them to follow this same procedure? Because our current policy includes everybody.
Yeah, I wouldn't see any reason why they wouldn't, so long as they are a WSBA entity. So yes, by all means, they should. And maybe we don't slow this process down by saying we need to adopt this policy and change it. Maybe we need a second step here for if there are additional committees and boards and whatnot. I would like to see this move forward, and then as maybe a second step to adopt that for committees specifically.
Yeah, I'm not trying to slow it down. I just didn't understand what was supposed to happen with the other entity.
I appreciate that. Thank you. Down by saying we need to adopt this policy and change it. Maybe we need a second step here for if there are.
Okay, I was a little confused by some echoing going on. If I might have a suggestion for this board as we have this discussion, in my mind, it was specifically to the sections where this conversation came out of, because we were recognizing the unique and rapid role that sections play in the WSBA and their need to respond to things, and as a collection of experts that advise on things. In my mind, we were discussing the sections, and the board might want to consider thoughtfully if this policy needs to be expanded to other groups. I'll now call on the people I have Governor-elect Williams-Ruth, followed by Governor Stevens, followed by Governor Grabicki, followed by a public comment. A phone starting 360 and ending in 526.
I just want to simply state something that Governor Stevens has said about the different ways in which people get information. Because a couple of years back, I worked with a state legislator to try and pass a amendment to a law based solely on my practice and something that was essential and needed for the a proper administration of justice. I got bipartisan support out of committee, and then the speaker killed it. I posted to the real property listserv, and no one wrote back about any way in which to seek formal approval. I had no idea there even was a legislative committee on how the WSBA could get behind legislation. So I would simply say that we look as the members of the WSBA are the ones interacting with all of the different RCWs, WACs, regulations, whatever, and we might want to weigh in and give some support, that we let our members know how to do that in multiple different ways, through the magazine, through notes. I mean, 2 months before the start of the legislative session, having to basically whip an entire bill by myself without the help of any of my colleagues, other than the section members that came along, was frustrating that it came to a dead end which may not have happened if I'd been able to get, like, say, the entire WSBA to get behind this specific legislation. So that's my comment.
So 2 comments with regard to that, Governor-elect. There in the policy, you'll see section 2, where training will be provided annually by the WSBA. That's one measure by which we're taking in order to inform folks as to the benefits and as to the processes. And then 2, Legislative Affairs Manager Walvikar has, we publicized that he is available for immediate contact and response for other questions and figuring out the process, because it can be complex and quick too, and so we want to make sure that we're responsive on a very tight timeline.
Right, and the point simply being that even though I was promoting out to the world that I had access to, I never knew about any of those other ones until I've now since joined our world here. But it was something that 2 years ago I would have really liked to known about.
You're on mute, President.
Thank you. I also didn't know about all this exciting legislative stuff before I became bog-elect, actually. Governor Stevens.
So I have a question for Governor Cicchetti on this, because as I'm listening to it and I'm actually looking at the policy before us. And by the way, I see not only what's the, I think, June 3rd draft, but then there are other items that are a part that I am assuming are for our edification and understanding and not the policy that we're trying to adopt. But I do recall that, and I understand what the general counsel is saying. I do recall that we saw as we were working on the sections policy, we saw this other policy, actually that few people were really looking at for a while because we were usually focusing so much on GR 12, and then we decided to try to harmonize that. But I think the point is well taken. The previous policy that applied to everyone also applied to the sections, but we didn't know in a way. This ends saying that this is going to supersede everything else, but it doesn't start saying that this is a policy for everything else. I'm wondering if this doesn't need to have some sort of technical review with the general counsel just to make sure that that the policy we're adopting, yes, is for the sections, but for everyone else, because it starts in one place, but it ends in another, and I'm not sure you need to do that, or you end it with this. These changes are for sections, and then you come back to do some other work with everything else, so everything is in alignment. Do you understand what I'm saying?
I do. And maybe my suggestion that we do it in 2 steps is not a good one. I'd welcome General Counsel Shanklin's advice on this.
So I guess pragmatically, the potentially fastest way, if you wanted to adopt this, then perhaps it just needs to be made clear that this replaces the old policy for sections, and that the board will sometime soon, July or whatever, determine what the status is of all the other WSBA entities. It just leaves a kind of a weird hole. I know this has been a huge amount of work and taken a huge amount of time, and I have not really had the ability to focus on it like I would have liked to. So I certainly do not want to delay your work. But we just need a way to make it clear. I mean, to me, this clearly pulls sections out of the old policy. But the words of this say the old policy disappears. And I think that just leaves other WSBA entities with like no clear path. If they want to comment, what do they do? And they don't have necessarily executive committees or things, that technically they could follow the same thing. They could probably follow the same process with a few different words.
All right. I appreciate that. And I think that's probably the best approach, given the fact that we may be facing a special session here shortly. And the sections are the most likely the ones that will want to approach the legislature and talk about things. In fact, I know that already from the tech section that's already gotten in touch with our legislative affairs manager. So I would be an advocate of that. Let's move forward with this policy, and then the legislative committee has more work to do, and we'll examine it for the other entities, not sections.
Governor Grabicki.
When this whole issue started, our largest section, RPPT, weighed in with comments. We then discussed it at the last meeting. RPPT then sent extensive red lines. Their key red line was not incorporated. They have a fundamental problem with Section 4D. They consider this to be a huge step back and to be something that is going to frustrate the hard work that they do with complex legislation, both in the estate and probate area and in the real estate area. They are adamantly opposed to this document as it stands today. I believe that both draw and family law also have serious problems with this. Two other huge components of our membership. So after we've completed some more discussion here, and I believe that there probably are people from RPPT Executive Committee and from draw and or family law that want to speak today about this. At that point, I'm going to move to table this thing and send it back and ask Kyle to sit down with key people from the sections that have got the real big issues here and see if he can't negotiate a solution that works for the legislative committee and for those sections. They are at this point truly bent.
Well, let me address that too. So we did talk with the family law folks and the RPPT folks, and I think some of the confusion with the RPPT folks was whether Legislative Affairs Manager Walvikar would still be available to them. And it sounded like that from their perspective, their interpretation, that would not be the case, that we would be pulling back. And I've never read subsection D that way, nor did anybody on our committee. I think that was more of a misunderstanding. There is a difference of opinion as to whether the section will need to come to the Board of Governors or come to the Legislative Affairs Manager and inform them and get permission to be able to go forward with their support or opposition to any kind of legislation. That is a bone of contention. It's my position, and I think the position of the committee, that there are restrictions to us from 12.2. The sections are not independent entities. They are entities of the WSBA, so they are bound by 12.2. And so we need that and I'm going to say it's a gatekeeping role, but it is a minor gatekeeping role. We're still allowing the sections to come to us quickly, that we will turn around as quickly as we can. We understand that the legislative session moves quite quickly and that decisions need to be made immediately. And I don't think we've had a problem with that before. It's just going further than that to allowing the sections to not have to get permission from the Bar Association, the very same entity, is problematic. That was the issue with regard to the committee. And I don't know that I see a way around that under the current current 12.2. Now, we have talked, and I have talked with General Counsel Shanklin about perhaps there are measures that could be taken, including a revision to 12.2 that might be able to loosen up some of those restrictions. And I envision this whole process as a living, breathing document that, we will need to look at over and over again, see what works, see what doesn't work. But this is a starting point, and I would encourage us to move forward on it and then work toward those goals of seeing if we can accomplish what the family law section and our RPPT eventually would like to do, separate and apart from our committee.
And all I'm saying is, I think that it would be most constructive if Governor Schicchetti and Julie took another run with the leaders of those two sections to see if you can find common ground. One of my concerns is that RPPT, with almost 3,000 members, may go the route of draw, which isn't going to be good for anybody, and we'll lose complete control of them. I just think that the politics of this, we ought to massage along. That's why I'm going to move the table at the appropriate time.
Taking a comment from phone number starting area code 360, ending in 526. You have a maximum of 3 minutes. Phone number with your hand up, ending in 526, from area code 360.
Can you hear me now?
Yes, ma'am.
This is Jean Cotton. I want to clarify a couple of things. First of all, in response to Julie, this was intended to replace what had been taken away from the sections. The prior policy had incorporated all these other quote-unquote entities. Prior to it, in 2012, I think it is, the policy was different for sections than it was for other boards and groups that are strictly controlled by the BOG. This was getting them back to the stage where the sections could testify. There's a process in place that's almost identical to what it was back before those wholesale changes that took away so much of the section's interest. And we explained this in great detail at the last meeting to the RPPT concerns that were just, unfortunately, I think, misplaced. It may be that your motion, if you move forward today, would be that this will replace all policies as related to sections addressing legislation and leave the other stuff there if you want and deal with that separately. As far as PJ's comment that draw was opposed to this, absolutely not. Absolutely not. We were very supportive of getting this back in place so that sections and other entities of the bar would have an opportunity to go to the legislature appropriately with the help of Sanjay so that we're not stepping on each other's toes. And this is the value you have when you have someone that's been around for a while. So thank you for letting me speak.
Thank you, Ms. Cotton. Next, we have Governor Higginson, and then we have Governor Stevens.
Thank you, Mr. President. In looking at the 2015 policy, under purpose, it says, this policy governs section, panel, committee, division, or council authority to comment publicly on court rules and legislation and so forth. So there's where the reference is to anything other than a section. So panel, committee, division, or council. As far as I'm aware, we don't have any panels on the WSBA. We do have committees, but just under normal governance practices. Committees are subsets of the WSBA and do not have independent authority to act. Division, I don't know what that even is. I don't think we have any. And council, I don't know that we have any councils. Someone may correct me, but my understanding is that any councils are separate from WSBA. They're
Council on Public Defense.
Council on Public Defense. All right. So that's fine. And they obviously know they need to come to us because they were here today asking for our permission to make some comments. So I guess I'd have to respectfully say, with regard to Julie's comments, that I think it would not be an issue to replace the 2015 policy with the policy that we have here, where I don't even see really, other than possibly the Council on Public Defense, who else would be impacted by this. Those are my only thoughts. I guess if we want this to be our life's work and continue to work on this and for another 6.5 months, that'll be up to a majority of the board. But the sections have wanted to be able to start knowing how they can proceed with regard to the legislature. And I would echo the comments that someone made here that they need guidance. They need to know, can they start commenting to the legislature and how do they do that? And if we put this off, they won't have that guidance. And I don't think that's in their best interest.
Just as a point of trivia, division most likely referred to our division that used to exist, which was the Young Lawyers Division, until they got demoted as a result of budget cuts and other politicking. Next, I have Governor Stevens.
Yes, I'd like to, and this is prior to what PJ wants to do, but to try to fix this, I'd like to propose an amendment to the last part of the draft. And it would read, this policy supersedes and replaces any and all prior policies on the same subject. And then the amendatory language would be, as it applies to sections, and then including but not limited to the WISBA legislation and court rules committee, et cetera, et cetera. So that we're making that clear that it's a sections application.
I heard a second from Governor Swagel, or?
Yeah.
Very good. And I have a comment waiting in the wings, which is from a phone number starting in 206, ending in 260.
Thank you very much. This is Devin McComb. I'm the Real Property Council Director of the RPPT section. Apologize, I had a little issue getting in on the phone. I was watching the video and have now dialed in. I would just speak briefly to the fact that I think there's no question, certainly from myself or the members of the executive committee of the RPPT section, as to the amount of effort and energy that has gone into this, or the amount of time that it's taken. I know that I think I've been in now 4 executive committees for our section that we've discussed this, and I think I've been watched or listened to 3 BOG meetings or legislative committee meetings on it. So I know there's a lot of energy and time that's been spent to get this policy in place. I think the issue from the section's perspective is that the goal of this policy is we've discussed as a group, or you've discussed as a group, is to clarify the process by which sections would comment on legislation and participate in those legislative process. And the problem we see it as that the modifications that were made, they don't make clear exactly how a section would do this. If this is to address the fact that there are potentially divergent positions from, say, the family law section and the real property section on an issue, and to harmonize those 2 positions, then that's a specific instance that we can address with language. But the idea of, in a very busy legislative session, for example, this January, I think we reviewed something like 130 real property related bills, and I know that our trust and estates partners are very active in helping craft legislation at the request of legislators. That in that time frame, that going and having a barrier for our ability to provide expertise, when we've already done as a section executive committee an analysis to say, okay, this isn't a GR12 issue, that putting an additional barrier in place is truly a problem. And it's a problem that currently is being created. It's not a problem that we have now. So if it's a question of reconciling divergent positions, then that's a specific issue. And it's to be addressed, I think, with a revision to the existing policy as opposed to a broader replacement. I think if you were to ask the average person on an executive committee of a section to read this policy and know what they could comment on and what they couldn't, and how to comment, you would be challenged. In the last legislative committee meeting, at the end of the discussion, there was discussion amongst the members there as to what does this actually say, and then there was discussion as to how will we summarize this for the BOG, because I don't know what we just voted on. So it's not that this is a poorly intentioned policy. It's not that there's been a lack of energy or commitment or drive or intelligence or anything like that. But I think that the product that it is being voted on and discussed creates some problems. And I think that with some additional work and effort, we can come up with something that preserves sections' roles, but also, advances the really good ideas that people have. So with that, I would just say thank you very much.
And okay, we had a motion and a second on the table to amend the policy proposed to be specifically referenced as this applies to sections.
Just a couple more.
Governor Cicchetti, please.
Yeah, just a couple more comments. And
we have time, Governor Cicchetti.
Pardon?
Don't feel rushed for time. We have time.
Okay. This has been a long process. And I think that the issues that Mr. McComb is identifying are present now. This policy does not affect the ability of the sections to go forward. In fact, it's intended to encourage that. The sticking point, as it is now, as we all know, is that the sections are not able to go out without getting permission from the Bar Association. They need to come to the Board of Governors or the Legislative Affairs Committee or the Legislative Affairs Manager before they approach the legislature. That hasn't changed. This policy isn't intended to change that. It can't change that under 12.2. And so maybe it could be made more clear, because there is some confusion about what the policy is intended to do. And I think, again, the Legislative Review Committee, the Legislative Committee, none of those, that's not going away. We're going to proceed forward, and we're going to continue to work with the sections, because the entire intent of this was entirely to free up the sections to be able to do more, to be able to present information to the legislature. Because that's what we heard about when we were down there for 1788. We heard from senators and representatives that they value the opinions of the Bar Association and the sections, and it's a tremendous resource for the legislatures to be able to rely on that information and that advice, that specialty and that skill. And so this came out. This was a product of that experience, and so really the intent is to move forward in that direction. I know in the past. And Gene Cotton mentioned this earlier, that there was sticking points in the past, but the intent of this policy was to move forward. We're not going to get around the fact that the sections have to come to the Board of Governors or the Legislative Affairs Manager for approval, because quite frankly, 12.2 doesn't allow that. And if that's the sticking point, if that's what is causing concern, under the current 12.2, we're not going to get around that. We're not going to have a policy that at least provides some guidance. Maybe it's not as articulated as it could be, just judging from the comments that have been made today. I would have thought otherwise. But I don't think this should be kick down the road and kick down the road and kick down the road. I think we should move forward and understand that it's not done. It will continue to be an effort. It will continue to be the focus of the Legislative Review Committee. It will continue to be the focus of the Legislative Committee, and we will make it better. But shutting it down and asking for more comments, I think, is a step backwards.
I move to table for the reasons previously stated by me and by Devin McComb, requesting that Kyle and Devin and the other interested parties get together and try and iron out the language in 4D. There were people on the Legislative Committee who were proponents of this who didn't vote for the last deal in the Legislative Committee because they confessed they didn't understand what all the language meant. This can be done in the next 2 weeks. It can come back at our July meeting and be approved. This doesn't have to drag on. This is 3 or 4 people sitting down and ironing out the language. That's all I'm asking for.
May I speak?
One moment. There's quite a line in front of you at the moment, actually, past President Piggott. Governor
Thank you.
Grabicki, I assume your motion is to the original underlying question, not the amendment that's been moved and seconded at the moment. Is that correct?
No, we could go ahead and vote on the amendment and then deal with the table on the underlying one. That's fine.
All right. Well, there hasn't been a second yet, but I hear the motion is on the table. I have a comment from 206.
I'm sorry, Mr. President.
Yes, Mr. Yes.
There has been a second for the amendment.
Oh, I'm sorry. I thought you were on. You must have been on mute, perhaps.
Governor Swingle seconded my amendment.
Oh, no, yeah. Just to keep everyone straight, the motion Governor Grabicki just made has not been seconded. The amendment that we're discussing at this moment, to add language about sections, has been moved and seconded. Absolutely correct. And you are in the queue. But first I have a phone number, 206, ending in 570.
Family law section. So have you, I want everyone to notice that the family law section's more extensive policy is in the BOG meeting materials starting at page 277. And we spent many, many, many hours on this, and many people worked on it to come up with a 4-prong approach to this policy. We believe it's a strong policy. We think it is more clear than the policy that's been proposed by the legislative committee. And we would share in the concerns raised by PJ and the concerns raised by RPPT that what has been proposed by the legislative committee is confusing, especially with regard to paragraphs 4C and 4D. I think that it clearly sets forth that we have to get permission from the Board of Governors or the legislative committee in writing, and then the next paragraph says we have to get permission from the legislative affairs manager, who then is supposed to be getting permission from the legislative committee if possible, and it's not clear what things fall under C and what things fall under D. And so it will be very confusing, and it is not the collaborative work-together approach that we have been told was going to be part of this policy. It is clear that the Board of Governors, the Legislative Committee, and the Legislative Affairs Manager are going to be not just gatekeepers, but gate closers on anything that we want to do. And I'm frustrated by the comments about 12.2, because we do, our section, all the sections, do a GR12 analysis. Our policy proposal also provides for training so that sections know how to do a GR12 analysis. We also provide that once it's been done on a particular topic, as long as a similar bill comes forward, then we're done with that analysis. The idea that the only people that can do a GR12 analysis is apparently everyone but a section is really both insulting to the expertise of sections and to the training process that we proposed, and which is included in both the legislative policy and the family law section proposed policy. The GR 12.2 does not say that the GR 12 analysis has to be done by the Board of Governors or Legislative Affairs Manager or Legislative Committee. It says by the Washington State Bar. Well, sections are a part of the Washington State Bar. We come out there, we say we are the family law section of the Washington State Bar Association. So our analysis and our comments should be treated just as seriously. Everyone loves Sanjay. I love Sanjay. He is open and welcoming. But there have been staff members in the past that were not so helpful with sections and cut off section involvement and insisted on scripts and wouldn't allow section representatives to answer simple questions. We cannot have a policy that is dependent upon the goodwill of some staff person in the future that we're not going to be selecting. Now, we totally understand that the rest of the Bar Association has an interest in good decisions, which is why I initially suggested that there be annual training. And that is part of our policy again.
Hey, Nancy, I just want, you've gone a little bit over time. So if you've repeated yourself, let's just get to your conclusion. I appreciate your comments, though.
Well, we would like that our policy be the one that is adopted. We think it is more thorough and addresses all of the concerns that everyone has had.
Thank you, Nancy. I appreciate you taking the time to be here and give these sentiments. I have Governor Stevens next in the queue, but Governor Cicchetti, could I just ask a point of information?
Yes.
If you mentioned there might be a legislative session coming up here very rapidly. Aren't there currently more barriers in place right now for the sections to be able to participate in that than under your policy?
More barriers in what way?
Well, we have this legislative session coming up. Say the sections want to get involved in that. Will this policy reduce barriers?
It's designed to facilitate it. Yes. Yes, in many ways it's designed to facilitate that so that we have a process by which the sections can come to us. We can make sure that the WSBA is not crosswise. That's not necessarily meaning on two different issues in opposition, but certainly we need to know, all of what's going on out there to make sure that we don't have, one section saying one thing and another section saying something else. It's part of the process here that we're trying to manage. It's not intended as an obstacle. It's just intended to coordinate the efforts of WSBA sections and WSBA, all of which are part of the WSBA. There's no distinction between the two. And just to mention on the problem that we had with Flex proposal, and I'll read it to you. It says the section is not required to obtain the permission of the Legislative Affairs Manager or the Legislative Committee before proceeding with comment and or testimony. So the Board of Governors then, or delegated to the Legislative Committee or delegated to the Legislative Affairs Manager, would not have any role in that. They could go directly under some circumstances to the legislature with their policies, and we wouldn't have any ability to say otherwise. Under 12.2, we have an obligation to abide by the rules. And I think it's the WSBA and the Board of Governors' responsibility to make sure that we're abiding by the rules. We are the organization, the governing body of the association. Now, again, we're trying to work forward so that there are more, it's easier and perhaps even, if we adjusted 12.2 to do what other states have done and maybe clarify it so that it's not just the administration of justice and practice of law, but it's also the improvement of law. That's been a suggested change to that rule. And I think that would be a good move in the same direction. I don't think that gets us away from saying that the sections still have to come to us because, again, that's our responsibility. But it does ease up even more restrictions on what could be said to the legislature. That's the intent of this.
Governor Stevens? Oh, I'm sorry.
Go ahead, Governor. Go ahead, President Majimdar.
I apologize. I didn't mean to cut you off. I thought that was the end of your... Governor Stevens?
So one of the things that I would hope we would do, because I'm wondering if, at least to some extent, if we are not distinguishing between policy and procedures that make those policies work. One of the things that you might recall I said, Governor Cicchetti, is that actually a number of sections that do a lot of work continuously should be able to get a blanket approval for a number of types of legislation that they do, so that they're not having to continue to go every time to get approval. And this would especially be in the area where we're talking about matters that are affecting the practice of law. They're very practice areas. And so I would hope we would try to figure that out, but I think we need to work through that. I would like, Mr. President, to at least get my little technical amendment out of the way that narrows this just to section policies regarding superseding other policies.
Then you must call the question.
So I'm calling the question on the amendment.
Somebody seconded that. Who seconded it?
This is for calling the question.
Can somebody second calling the question?
I second.
I'll second it.
Okay, I heard Peterson first, and then I heard Clark. There's a question on the table called the question of the amendment to specify this applies to sections. I actually have the exact language here. It said, this policy supersedes and replaces any and all prior policies on the same subject, adding language as it applies to section. Okay. And then the rest of the sentence. Governor Abell, on calling the question.
Aye.
Governor Angelville.
Aye.
Governor Clark.
Aye.
Governor Higginson.
Can I vote? I don't care.
Gravicki.
Aye.
Wait. Governor Higginson, what was your vote? I'm sorry.
Other than I don't care, aye.
Governor Gravicki?
Yes.
He's having trouble with his sound.
Okay, Oracle, I'm going to come back to you.
Okay.
Governor Knight? Governor McBride?
Aye.
Governor Peterson?
Yes.
Governor Cicchetti?
Aye.
Governor Stevens?
Aye.
Governor Swagel?
Aye.
Governor Tollefson?
Yes.
Back to Grabicki. I'll count him as not voting on this. 1, 2, 3, 4, 5, 6, 7, 8, 9. 10 votes in favor, none against. The question is called on to amend the policy with the section language. Governor Abell.
Mr. President, to clarify, the motion before us now is to approve the policy with the amended language. Is that correct?
No, just to amend the language onto the policy.
Oh, I see. Thank you, Mr. President. Appreciate it. Aye.
Governor Angelville.
Aye.
Governor Clark.
Aye.
Governor Grabicki. Still frozen out of us. Governor Higginson.
No.
Governor Knight. Governor McBride.
Aye.
Governor Peterson.
Yes.
Governor Cicchetti.
Aye.
Governor Stevens.
Aye.
Governor Swagel.
Aye.
Governor Tollefson.
No.
Rajiv,
In favor, 2 against. The motion carries. The proposal on the table is amended.
Mr. Chair? Yeah, I think Governor Grabicki I think he was rebooting, and I think he's back now if you want to take his vote. There he is.
Well, Governor Grabicki, I could take your vote on the question to amend the policy to add the language regarding that this applies to sections in particular.
Yes.
That changes the vote total. 9 in favor, 2 against. The motion carries. The policy on the table being considered is amended. Okay. And then Governor Stevens, I think I had your hand up from before, so I'm going to lower that. I don't think you meant to have it up again. Any more discussion or question? We are now back to the original question of approval of this policy. I'm not seeing any more hands.
You got a second on my motion to table?
I did not. I'm now moving to take a roll call vote on the policy itself. Governor Abel.
Aye.
Governor Angeville.
Aye.
Governor Clark.
Aye.
Governor Grabicki.
No.
Governor Higginson.
Aye.
Governor Knight. Governor McBride.
Aye.
Governor Peterson.
Yes.
Governor Schicchetti.
Aye.
Governor Stevens.
Aye.
Governor Swagel.
Aye.
Governor Tollefson.
I vote yes.
10 votes in favor, 1 against. The motion carries. The policy shall be adopted as amended and specified. Now I'm going to wrap this up. Governor Schicchetti, head of the Legislative Review Committee, and our president-elect, has committed to making this a living process. Governor Grabicki, I would appreciate if you would liaison with the people who have reached out to you with concerns, and I would work on an amendment to bring back to this board, okay? We have something in place. We're going to move forward on it. I would encourage you to do that process. I think Governor Schicchetti is open to that, and I think this board wants the best policy. We've heard some feedback here about clarity, and we have some debates to talk about. Let's not stop this process. We have adopted this policy today. It is not a dead document. It's going to be a living process. Governor Grabicki, I would ask that you please try to head up the engagement on this issue. I would appreciate that.
I will reach out to Nancy and to the executive committee of RPPT and see if they can bring something to Kyle that can lead to some further discussion.
Thank you.
I appreciate that as well. Thank you.
And just to check with Director Nevitt and my team that's supporting me, before we get to the diploma privilege issues, have I forgotten everything on the agenda? I think I've gotten everything else done. And we're only 12 minutes off of my hopeful schedule.
I think the only thing we didn't do was the governor liaison reports.
Correct. And I don't know when I will get to that if I do, but for the moment, we're skipping over it. Only to encourage you all to somehow safely and legally, virtually do your liaison duties and tasks and carry them out. I know that my liaisoning as president has plummeted quite a bit without my physical ability to see people. Okay, we're going to move on to diploma privilege issues, but we've been talking for a while. It's a little warm in my office. I think someone might have turned off the air conditioning. I'm going to propose we take an 8-minute break and convene at 4:50. I'll see you all in a few moments.
Rajiv, how long do you expect to go?
Well, it's a very verbose group of people, but, you know, I'm hoping that we will be done by 5:30 today.
DJ, will you be speaking?
Okay, everyone. I'll see you at 4:50 in 7 minutes.